This program is being brought to you by the Wellesley Council on Aging. Hello to all of you watching on Wellesley Public Media. The views and opinions expressed are those of the author and do not necessarily reflect the official policy or position of the Wellesley Council on Aging or Wellesley Public Media. Any content that I provide is of my own personal opinion and is not intended to malign any religion, ethnic group, club, organization, company, individual, or anyone or anything. Hello, everyone. I'm John Horrigan, and welcome to Journey Through the Past. In this edition, It's My Seat, the story of African-American women who refused to give up their seat for a white person. This is part one of It's My Seat. Discretion is strongly advised. I now must advise all who are viewing this presentation that I will be using two outdated terms that were predominant in historical records, and they may be offensive to you. I will pause now so you have time to stop viewing this presentation and safely move away. Those two terms are Negro and colored people. Now, these two antiquated terms show up in historical records and court transcripts that we'll be reviewing. For instance, we're going to be reading transcripts from the Browder versus Gale case of 1956, and they even show up in some esteemed national civil rights organizations such as the NAACP, which is an acronym for the National Association for the Advancement of Colored People. And I will attempt to use African American in place of these terms. The program is called It's Her Seat, or It's My Seat. This is a chronology of the struggle for civil rights endured by selective African-American women with a focus on the events that led up to the Montgomery bus boycott in 1955. They took a stand for equal rights by remaining seated. Now, there were and still are millions of acts of discrimination that have been and still are committed against African-American males as well as African-American females. The enforced segregation events that took place in Montgomery, Alabama during 1955 are just a microcosm of the hostilities that African Americans have had to endure for over 400 years. My information is gleaned from various resources, including biography.com, history.com, blackpast.org, nationalhumanitiescenter.org, wikipedia.org, civilandhumanrights.org, the New York Times, Smithsonian, Washington Post, and other various periodicals of the period. We're going to talk about Elizabeth Jennings, Ellen Anderson, Ida B. Wells, Irene Morgan, Sarah Keyes, Mary Fair Burks, Joann Robinson, Georgia Gilmore, Aurelia Browder, Claudette Colvin, Mary Louise Smith, and finally conclude with Rosa Parks. We'll also refer to the Emancipation Proclamation, the 13th, 14th, and 15th Amendments to the U.S. Constitution, the New York Draft Riots of 1863, Reconstruction, the Compromise of 1877, and then three court cases: Plessy versus Ferguson, 1896, Brown versus the Board of Education, 1954, and Browder versus Gale, 1956. Let's start off with Elizabeth Jennings Graham. She was born March in 1827 and passed away on June 5th, 1901. She was an African-American teacher and civil rights figure. In 1854, Graham insisted on her right to ride on an available New York City streetcar at a time when all such companies were private and most operated segregated cars. Her case was decided in her favor in 1855, and it led to the eventual desegregation of all New York City transit systems by the year 1865. Now, she was born free in March 1827, and her parents were Thomas L. Jennings, on the right, and his wife, who was also named Elizabeth, and they had at least 5 children. He was a free black, and she was born into slavery. Thomas Jennings became a successful tailor and an influential member of New York's black community, being the first known African-American holder of a patent in the United States. In 1821, he was awarded a patent from the U.S. government for developing dry scouring, which was a new method to clean clothing. With fees from his patented dry cleaning process, Thomas Jennings bought his wife's freedom, as she was considered an indentured servant until 1827 under the state's gradual abolition law of 1799. But their daughter Elizabeth was thus born free and received an education. Now, with Elizabeth, we're going to talk about the daughter Elizabeth. She later started the city's first kindergarten for African-American children, operating it from her home on 247 West 41st Street until her death at age 74 in 1901. Now, Jennings' mother, Elizabeth, was a prominent woman known for penning the speech on the improvement of the mind, which 10-year-old Elizabeth Jennings delivered at a meeting of the Ladies' Literary Society of New York, which was founded in the year 1834 and of which Jennings' mother was a member. The Literary Society was founded by New York's elite black women to promote self-improvement through community activities, reading, and discussion. It was produced and given in 1837, and the speech discusses how the neglect of cultivating the mind would keep blacks inferior to whites and would have whites and enemies believe that blacks do not have any minds at all. Jennings believed the mind was very powerful and its improvement could help with the abolition of slavery and discrimination. Therefore, she called upon black women to develop their mind and take action. The importance of improving the mind was a consistent theme among elite black women. By 1854, Jennings became a school teacher and also was the church organist. And she taught at the city's private African free school, which had several locations by this time, and later in the public school system. Now, in the 1850s, the horse-drawn streetcar on rails became a more common mode of transportation, competing with the horse-drawn omnibus in New York City, an omnibus like a wagon. Elevated heavy rail, the next transportation mode in the city, didn't go into service until about 1869. But like the omnibus lines, the streetcar lines were owned by private companies, and their owners and drivers could refuse service to any passengers and enforce segregated seating. On Sunday, July 16, 1854, Elizabeth Jennings went to the First Colored Congregational Church, where she was an organist. As she was running late, she boarded a streetcar of the 3rd Avenue Railroad Company at the corner of Pearl Street and Chatham Street in New York City. That's the location today. Now, the car didn't carry the requisite sign reading, "Colored people allowed in this car," but the driver pulled over to allow Jennings and a companion to board. However, the conductor, not the driver, who was responsible for collecting fares, physically blocked Jennings from entering the car once she stepped onto the platform, and an altercation ensued. The conflicting signals given by the driver, who pulled over to let Elizabeth on, and the conductor, who stopped her from boarding, show just how arbitrarily segregation was enforced at the time. By her own account, published in the New York Tribune a few days later, Jennings stated that the police officer called to the scene sided with the conductor, even though she was the one that had been assaulted. The conductor ordered her to get off. When she refused, the conductor tried to remove her by force. Eventually, with the aid of a police officer, Jennings was ejected from the streetcar. She was hurled onto the muddy, smelly street in New York City wearing her best Sunday clothes. Now, Horace Greeley, a great writer from the New York Tribune, commented on the incident in February of 1855. This is Greeley's article. "She got upon one of the company's cars last summer on the Sabbath to ride to church. The conductor undertook to get her off, first alleging the car was full. When that was shown to be false, he pretended the other passengers were displeased at her presence. But when she insisted on her rights, he took hold of her by force to expel her. She resisted. The conductor got her down on the platform, jammed her bonnet, soiled her dress, and injured her person. Quite a crowd gathered, but she effectually resisted. Finally, after the car had gone on further, with the aid of a policeman, they succeeded in removing her." This is Elizabeth's exact words. "I held my gloved hand up to the driver, and he stopped the cars. We got on the platform when the conductor told us to wait for the next car. I told him I could not wait, as I was in a hurry to go to church. He insisted upon my getting off, but I did not get off. He waited a few minutes when the driver, becoming impatient, said to me, 'Well, you may go in, but remember, if the passengers raise any objections, you shall go out. Whether or not, I'll put you out.' I told him not to lay his hands on me. He took hold of me, and I took hold of the window sash and held on. He pulled me until he broke my grasp, and I took hold of his coat and held on to that, but previously he had dragged my companion out. She was all the while screaming for him to let go of me. A crowd gathered. The driver then went to his horses. I went again into the car. The conductor said, 'You shall sweat for this.' He then told the driver to drive as fast as he could and not to take another passenger in the car to drive until he saw an officer or a station house. We saw an officer at the corner of Walker and Bowery, and he, without listening to anything that I had to say, thrust me out and then pushed me down and tauntingly told me to get redress if I could. I would have come up myself, but I'm quite sore and stiff from the treatment that I received from those monsters in human form yesterday afternoon." The incident sparked an organized movement among black workers to end racial discrimination on streetcars, led by notables such as Jennings' father and also Pictured here in the upper right, Reverend James W.C. Pennington and Reverend Henry Highland Garnett, lower right. Her story was publicized by Frederick Douglass in his newspaper, and it received national attention. Now, Jennings' father filed a lawsuit on behalf of his daughter against the driver, the conductor, and the Third Avenue Railroad Company in Brooklyn, where the Third Avenue Company was headquartered. This was one of 4 streetcar companies franchised in the city and had been in operation for about a year. Now, she was represented by the law firm of Culver, Parker, and Arthur. Her case was handled by the firm's 20-year-old junior partner, Chester A. Arthur, who would become a future U.S. president. You can see him in his youth on the left, and then as president on the right. Now, I must say this about Arthur. He vetoed the first version of the 1882 Chinese Exclusion Act, arguing that his 20-year ban on Chinese immigrants to the United States violated the Burlingame Treaty. But then he signed a second version, which included a 10-year ban. So in 1855, the court ruled in Elizabeth Jennings Graham's favor. In his charge to the jury, Brooklyn Circuit Court Judge William Rockwell declared, "Colored persons, if sober, well-behaved and free from disease, had the same rights as others and could neither be excluded by any rules of the company nor by force or violence." The jury awarded Jennings damages in the amount of $250, which is roughly comparable today to $8,000, anywhere from $8,000 to $12,000. And they also gave her $22.50 in court costs. The next day, the Third Avenue Railroad Company ordered its cars desegregated. However, the decision did not apply to all of the city's streetcar lines, which were individually owned and operated. And this was long before the Unified Metropolitan Transportation Authority came into existence, the MTA. And each line then had to be challenged separately in court. In an effort to avoid confrontations like the one between Elizabeth Jennings and the Third Avenue line's conductor, the Sixth Avenue Railroad increased the number of its cars available to African Americans beginning in October 1854. As important as the Jennings case was, it didn't mean that all streetcar lines would desegregate. Leading African American activists formed the New York Legal Rights Association to continue the fight. I want to talk about George Thomas Downing, 1819 to 1903, known as Thomas Downing. Also in 1855, Thomas Downing, a well-known African-American caterer, made a mockery of the Sixth Avenue line's segregated system by daring anyone to stop him. He was 64 years old, from riding uptown. They stopped the omnibus, and he was followed by a band of determined supporters who pushed the car forward when the driver refused to go. Now, James W.C. Pennington was arrested and convicted in 1859 for riding in a white-only streetcar operated by 8th Avenue Railroad, and he was represented by the Legal Rights Association, which had been formed by Elizabeth's father, Thomas L. Jennings. Now, he challenged the system successfully and on appeal gained an 1855 ruling by the state Supreme Court that such racial segregation was illegal and must end. By 1865, after starts and stops, all the streetcar companies had desegregated their systems. Now, Elizabeth Jennings married Charles Graham, who lived only to be 37. He died in 1867, and he was from Long Branch, New Jersey. And they were wed on June 16, 1860 in Manhattan. They had a son, Thomas J. Graham, but he was a sickly child who died of convulsions at the age of 1 during the New York draft riots of July 16, 1863. Let's look at the New York draft riots. As the Civil War progressed, New York's anti-war politicians and newspapers kept warning its working-class white citizens, many of them Irish or German immigrants, that emancipation would mean their replacement in the labor force by thousands of freed enslaved people from the South. Facing a dire shortage of manpower in early 1863, Abraham Lincoln's government passed a strict new conscription law, a draft, which made all male citizens between the ages of 20 and 35 and all unmarried men between 35 and 45 subject to military duty. Though all eligible men were entered into a lottery, they could buy their way out of harm's way by hiring a substitute or paying $300 to the government, which is roughly $5,800 today. At the time, the sum was the average yearly salary for the average American worker, making avoiding the draft impossible for all but the wealthiest of men. And compounding the issue, African Americans were exempt from the draft as they were not considered citizens. So the mobs attacked government facilities on July 13th, 1863, and then they turned their violence on African Americans. By far, the worst violence was reserved for African American men, a number of whom were lynched or beaten to death with shocking brutality. In all, the published death toll of the New York City draft riots was 119 people, though estimates of the actual number of people killed has reached as high as 1,200. With the assistance of a white undertaker, the Grahams slipped through mob-filled streets and buried their deceased child in Cypress Hill Cemetery in Brooklyn. The funeral service was read by Reverend Morgan Dix of the Trinity Church on Wall Street. Now, after the New York draft riots, there were numerous attacks against the African-American community in New York. So the Grahams left Manhattan with her mother to live with her sister Matilda in Monmouth County, New Jersey, in or near the town of Eaton. Charles died in 1867 while they were living in New Jersey, and Elizabeth, along with her mother and sister, moved back to New York City in the late 1860s or 1870. Graham lived her later years at 247 West 41st Street, and she founded and operated the city's first kindergarten for Black children in her home. She died on June 5th, 1901 at the age of 74, and according to her tombstone, she was buried in Cypress Hill Cemetery along with her son and husband. In 2007, New York City co-named a block of Park Row as Elizabeth Jennings Place. On January 2nd, 2018, the first biography of Elizabeth Jennings was published, written by Amy Hill Harth. It was entitled Streetcar to Justice, How Elizabeth Jennings Won the Right to Ride in New York, and intended for middle grade to adult readers, and the book was published by HarperCollins Green Willow Books in New York. A note here, we also did a segment on her on The Folklorist. Please check it on YouTube. Now let's talk about the Emancipation Proclamation, 1863. President Abraham Lincoln issued the Emancipation Proclamation on January 1st, 1863, as the nation approached its third year of a bloody civil war. The proclamation declared that all persons held as slaves within the rebellious states are, and henceforward, shall be free. Now, it applied only to states that had not seceded from the United States, leaving slavery untouched in the loyal border states and territories. It also expressly exempted parts of the Confederacy, that is, the Southern secessionist states, that had already come under Northern control. Most important, the freedom it promised depended upon a Union victory by the military. Although the Emancipation Proclamation didn't end slavery in the nation, it captured the hearts and imagination of millions of Americans and fundamentally transformed the character of the war. After January 1st, 1863, every advance of federal troops expanded the domain of freedom. Moreover, the proclamation announced the acceptance of Black men into the Union Army and Navy, enabling the liberated to become liberators. And by the end of the war, almost 200,000 Black soldiers and sailors had fought for the Union and freedom. Now let's talk about Charlotte Brown Riker, born 1839, unclear as to what date she passed. She was an American educator and civil rights activist who was one of the first to legally challenge racial segregation in the United States when she filed a lawsuit against a streetcar company in San Francisco in the 1860s after she was forcibly removed from a segregated streetcar. Born in Maryland in 1839, the daughter of James E. Brown, who was born enslaved, and Charlotte Brown, who was a free seamstress. The elder Charlotte Brown purchased her husband's freedom, and in 1850 they were living as free people of color in Baltimore, Maryland, with several children, including Charlotte. Now, sometime between 1850 and 1860, they moved their family to San Francisco, which was booming as a result of the California gold rush, and became a part of that city's burgeoning Black middle class. The Black population of the city at that time was 1,176 people, or about 2% of San Francisco's population. Now, at 8 o'clock in the evening on April 17, 1863, Charlotte Brown took a seat on a horse-drawn streetcar 1 block from her home on Filbert Street in San Francisco. She was on her way to see her doctor, and the streetcar was owned by the Omnibus Railroad Company. And when the streetcar conductor approached her and asked her to leave, Brown said she, quote, had a right to ride and had no intention of leaving the car. In her courtroom testimony, she stated, quote, the conductor went around and collected tickets, and when he came to me, I handed him my ticket, and he refused to take it. It was one of the Omnibus Railroad tickets, one that I had purchased of them previous to that time. He replied that colored persons were not allowed to ride. I told him I had been in the habit of riding ever since the cars had been running. I answered that I had a great ways to go, and I was later than I ought to be. The conductor, named Thomas Dennison, asked her several times to leave, and each time she refused. Finally, when a white woman objected to her presence, he grabbed her by the arm and escorted her off the car. Her father, James E. Brown, hired attorney Wc Bardette, and Charlotte Brown brought a lawsuit against the Omnibus Railroad Company for $200. Now, African Americans had just won the right to testify against whites that same year. So, Charlotte Brown versus the Omnibus Railroad Company. The case took 2 years, 3 years almost to litigate, 1863 to 1865. The Omnibus Railroad argued that its conductor's action was justified because racial segregation protected white women and children who might be fearful or repulsed by riding in the same car as African Americans. The conductor Dennison was convicted in criminal court of assault and battery against Charlotte Brown. Brown's civil case was tied up in appeals for the next 2 years. In one retrial, the jury awarded Brown only 5 cents, the price of the streetcar ticket. Meanwhile, just 3 days after the first trial, Brown was ejected from yet another streetcar and brought a second lawsuit against Omnibus, this time for $3,000, and she would even try it a third time. So finally, in October 1864, her case was tried in a higher court, and in his judgment of October 5th, 1864, Judge Orville C. Pratt of the 12th District Court upheld the earlier verdict in favor of Charlotte, ruling that excluding passengers from streetcars because of their race was illegal. He had, quote, no desire in his ruling to perpetuate a relic of barbarism. Now, here's a racist editorial cartoon that was published in San Francisco in 1865 after Charlotte won a lawsuit against the segregated San Francisco streetcar company Omnibus. And in January of 1865, a jury awarded Charlotte Brown $500. Let's look at Mrs. Ellen Anderson, born, we think, around the year 1829, not sure of the year she passed. But it's late in the morning of Friday, June 17, 1864, when a well-dressed colored woman, about 35 years of age, stood at the corner of Broadway and 8th Avenue in New York City. She was tired and unwell and wanted nothing so much as to get home. She was dressed in deep mourning. Not long before, she had received official notice that her husband, Sergeant William Anderson from Company F 26th USCT, had accidentally drowned while in the course of duty at Beaufort, South Carolina. Car number 2 of the 8th Avenue Railway drew to a halt, and Mrs. Ellen Anderson mounted the horse-drawn car. She sank onto the bench, glad to get off her feet, and then reached for her purse to pay the fare. But the conductor, rather than taking her money, told her she would have to get off. The smaller, more rickety car, clearly marked as for colored patrons, would be by shortly. Well, out on the street, Ellen Anderson had no choice but to wait for the colored car. But she was angry now, and she wasn't going to let this outrage pass unchallenged. The very next day, letters from eyewitnesses began to appear in the press. A vocal portion of the public, it seemed, agreed that injustice had been done. She went to see Charles C. Whitehead, a white lawyer known for welcoming colored clients, to see what her options were. She found that there was no law prohibiting a railroad company from making rules regarding the use of its cars. Their charter, however, requires that they provide service for the entire population. About 10 years earlier, a ruling was made that as long as adequate service was made available to colored patrons, the service could be segregated. Separate but adequate, you might say. Now, Anderson brought a suit against the police officer who had aided a conductor in removing her from the streetcar. In the court transcript, this is exact. The case of Ellen Anderson, the widow of Sergeant Anderson of Company F and the 26th Colored Regiment, who was forcibly ejected by police officer Tyler from one of the cars of the 8th Avenue Railroad, came before the police commissioners this Wednesday morning, a charge of assault having been preferred at her instance against the officer and of breaking the police regulations. Mr. Charles E. Whitehead, attorney, acting for William Curtis Noyes, Esquire Counsel, appeared for the complainant. Her testimony, quote, I am a widow of Sergeant Anderson of Company F, 26th Regiment, who died in discharge of his duty at Beaufort, South Carolina. I was going up home and standing at the corner of Broadway when car number 2 of the 8th Avenue Railroad came up. I got in. The conductor came up and said I could not ride in it. I told him I was sick and wished to go home. He said there would be another car along soon. I told him I wished to ride in that. He started up and put his hands on me. I told him not to touch me. Then he went out and brought in a policeman. This is the man here, she points to him. He came in and told me there would be another car along soon. I said I knew nothing about another car and had a right to ride there as well as anywhere else. He said I could not ride and must go out, and then got hold of me and dragged me and called to the conductor for assistance. The conductor came and they got me off the seat. I got hold of the straps of the car, and then they both pulled me and dragged me so that I was very sore, and they tore my hand and at least succeeded in dragging me into the street. The conductor said he did not care for me or my husband. I had money with me to pay my fare. Nobody asked me for any money. I had a basket in my hand. So the directors of the 8th Avenue line said that they had established no policy regarding separate cars. It was a decision of lower management, simply a development of how things were done rather than a company policy. C.A. Runkle, Esquire, lawyer, confirmed the complainant's statement as to the manner of her ejection and the parties engaged in it, and in answer to a question by defendant, said there was no more violence used than was necessary to take her out, i.e., that's how we normally took black people off of cars. J.P. Cummings, Esquire, a director of the 8th Avenue Railroad, said there was no order excluding colored citizens from the use of the 8th Avenue Railroad cars, and on cross-examination said he did not know there were signs on the road saying colored people were allowed to ride in certain cars only. That's a blatant lie, or an incompetent buffoon that didn't know what was going on in his own company. And he said that no orders had been issued by the board to the conductors to reject colored people. Again, a lie, or he's totally disconnected from his own firm. Attorney Charles Whitehead suggested that they, quote, ask what right these conductors have to call on police officers to help them do their dirty work, and what right the police officers have to lay their hands on anyone who is not an offender against the law. Quote, it is a question whether the railway companies may, by their charters, exclude colored people, but it is not a legal obligation for them to do so. And it is no offense to law by a colored person to be found in a public conveyance. Then he says, I infer that any officer who lends himself to this business is personally liable to a prosecution for assault and battery. Ellen Anderson won that case. Let's look at the 13th Amendment to the U.S. Constitution, 1865. In the aftermath of the Civil War, it abolished slavery in the United States. The 13th Amendment states, neither slavery nor involuntary servitude, except as a punishment for crime whereof the party shall have been duly convicted, shall exist within the United States or any place subject to their jurisdiction. Now the case of Mary Ellen Pleasant. We think she was born anywhere between the year 1812 and 1817. We know she passed in 1904. She was a 19th century American entrepreneur, a financier, a real estate magnate, and an abolitionist. And she identified herself as a capitalist by profession. She worked on the Underground Railroad and helped bring it to California during the Gold Rush era. Now, she was a lover, some say, friend and financial supporter of John Brown, and well known in abolitionist circles. John Brown had the insurrection at Harper's Ferry. He was an abolitionist. So after the Civil War, she won several civil rights victories, one of which was cited and upheld in the 1980s and resulted in her being called the mother of human rights in California. Now, when Mary Ellen arrived in San Francisco, she passed as white, using her first husband's name among the whites, and took jobs running exclusive men's eating establishments, starting with the Case and Heiser. She met most of the founders of the city as she catered lavish meals, and she benefited from the tidbits of financial gossip and deals usually tossed around at the tables. She's a good listener. She engaged a young clerk named Thomas Bell at the Bank of California, and they began to make money based on her tips and guidance. Now, Thomas made money of his own, especially in quicksilver, and by 1875, they had together amassed a $30 million fortune, which today is roughly $647 million. The partnership, though, was seen by many as illicit, and the mansion she built in San Francisco for herself and Bell and his family was thought to be a brothel. Now, Pleasant didn't conceal her race from other blacks and was adept at finding jobs for those brought in by the Underground Railroad. And she left San Francisco from 1857 to 1859 to help John Brown, and she was said to have actively supported his cause with money and work. In fact, there was a note from her, it's believed, in Brown's pocket when he was arrested after the Harper's Ferry incident, and it was only initialed as MEP. And this is her words. She said in that letter, "The axe is laid at the foot of the tree. When the first blow is struck, there will be more money to help." Now, after the Civil War, Mary Ellen Pleasant publicly changed her racial designation in the city directory from white to black, and this caused a little stir among some whites. She began a series of court battles to fight laws prohibiting blacks from riding trolleys and other such abuses. She filed 2 lawsuits, the first against the Omnibus Railroad Company, and it was withdrawn after the company promised to allow African Americans to board their streetcars. The second case, Pleasant versus North Beach and Mission Railroad Company, went to the California Supreme Court and took 2 years to complete. In the city, the case outlawed segregation in the city's public conveyances. However, at the state Supreme Court, the damages awarded against her at the trial court were reversed and found excessive. Now let's look at the 14th Amendment to the United States Constitution, ratified in 1868. It granted citizenship to all persons born or naturalized in the United States, including former enslaved people, and guaranteed all citizens equal protection of the laws. One of the 3 amendments passed during the Reconstruction era to abolish slavery and establish civil and legal rights for Black Americans, it would become the basis for many landmark Supreme Court decisions over the years. Now let's look at Catherine Brown, born 1840, passed 1883. She was a U.S. Senate employee in charge of the ladies' retiring room. On February 8, 1868, Brown boarded a train to travel from Alexandria, Virginia to Washington, D.C., and she entered, quote, what they call the white people's car. As she was boarding, a railroad policeman told her to move to a different car. He told her the car she had entered was for ladies and no damned, that's the N-word, was allowed to ride in that car. Never was and never would be. She replied, this car will do. The railroad police officer and another employee grabbed Brown, and after a violent struggle that lasted 6 minutes, in which she was beaten and kicked, and they threw her on the boarding platform, dragged her along the platform, and threatened to arrest her. Brown's injuries were so severe that she was bedridden for several weeks and spit up blood. Senators Charles Sumner and Justin Morrill called for a formal investigation, and Senator Charles Drake agreed, and a resolution was passed on February 10th, and Senate committee heard testimony later that month. Now, Brown sued the railway company for damages, and she was awarded $1,500 in district court. The railway company appealed, and the case eventually went before the U.S. Supreme Court. On November 17, 1873, in an opinion delivered by Justice David Davis, the court held that racial segregation on the railroad line was not allowed under its congressional charter, which stated, quote, no person shall be excluded from the cars on account of race. Davis dismissed the company's separate but equal argument as an ingenious attempt to evade a compliance with the obvious meaning of the requirement of the 1863 charter that had been decided in favor of Charlotte Brown. The court held that white and black passengers must be treated with equality in the use of the railroad's cars, and Kate Brown recovered from her injuries and remained a Senate employee until the year 1881. Now let's look at the 15th Amendment to the U.S. Constitution, ratified in 1870. It states, the right of citizens of the United States to vote shall not be denied or abridged by the United States or by any state on account of race, color, or previous condition of servitude. It granted African American men, not women, the right to vote, and it was adopted into the U.S. Constitution in 1870. But despite the amendment by the late 1870s, discriminatory practices were used to prevent blacks from exercising their right to vote, especially in the South. And it wasn't until the Voting Rights Act of 1865 that legal barriers were outlawed at the state and local levels if they denied African Americans their right to vote under the 15th Amendment. Let's look at the Reconstruction Era. That was the period in American history that lasted from 1865 to 1877 following the American Civil War, and it marked a significant chapter in the history of civil rights in the United States. Reconstruction ended the remnants of Confederate secession and abolished slavery, making the newly freed slaves citizens with civil rights, ostensibly guaranteed by 3 new constitutional amendments, 13th, 14th, and 15th. But Reconstruction also refers to the attempt to transform the 11 Southern former Confederate states as directed by Congress and the role of the Union states in that transformation. Compromise of 1877. This led to the withdrawal of federal troops from the South, and Democrats consolidated control of state legislatures throughout the region, effectively marking the end of Reconstruction. And then they basically used the former slaves as indentured servants, put them in debt, loaning them tools and seeds so they could farm, but then charging them exorbitant rates along with interest. They were still slaves. Now, Southern Black people saw the promise of equality under the law embodied by the 13th Amendment, 14th Amendment, and 15th Amendment to the Constitution receding quickly in a return to disenfranchisement and other disadvantages as white supremacy reasserted itself across the South. Let's look at Sally Robinson, born in the year 1851. We're not sure of the year she passed. She was a 19th century African-American civil rights activist, and on the evening of May 22nd, 1879, Sally Robinson, a 28-year-old black woman, bought 2 first-class tickets at Grand Junction, Tennessee, for a train trip to Lynchburg, Virginia. Shortly after midnight, she and her nephew, Joseph Robinson, described as a young black man of light complexion, light hair, and light blue eyes, boarded the train and started into the parlor car. The conductor held Robinson back, she said, bruising my arm and jerking me roughly around, and pushed her into the smoking car. A few minutes later, when Joseph informed the conductor that he was Robinson's nephew and was an African-American, the conductor looked surprised. In that case, he said, they could go into the parlor car at the next stop. The Robinsons finished the ride in the parlor car, but filed complaints with the railroad about their treatment and then sued for $500 under the Federal Civil Rights Act of 1875. At trial, the conductor testified that he had thought Joseph to be a white man with a black woman, and his experience was that such associations were for illicit purposes. The jury found for the railroad, and the Robinsons appealed to the U.S. Supreme Court, where they lost. Let's talk about Ida B. Wells Bardette, born 1862, passed 1931. Quote, and she said this in 1892, "The way to right wrongs is to turn the light of truth upon them." Ida B. Wells Bardette was a prominent journalist, activist, and researcher in the late 19th and early 20th centuries. In her lifetime, she battled sexism, racism, lynching, and violence. As a skilled writer, Wells Bardette also used her skills as a journalist to shed light on the conditions of African Americans throughout the South. In the 1890s, Wells documented lynching in the United States in articles and through a pamphlet called Southern Horrors, Lynch Law in All Its Phases, investigating frequent claims of whites that lynchings were reserved for black criminals only. Not true. She exposed lynching as a barbaric practice of whites in the South used to intimidate and oppress African Americans. A white mob destroyed her newspaper office and her presses as her investigative reporting was carried nationally in black-owned newspapers. On May 4th, 1884, a train conductor with the Chesapeake and Ohio Railroad ordered Ida Wells to give up her seat in the first-class ladies' car and move to the smoking car, which was already crowded with other passengers. The previous year, the Supreme Court had ruled against the Federal Civil Rights Act of 1875, which had banned racial discrimination in public accommodations. This verdict supported railroad companies that chose to racially segregate their passengers. When Ida B. Wells refused to give up her seat, the conductor and 2 men dragged her out of the car. Wells gained publicity in Memphis when she wrote a newspaper article for The Living Way, a black church weekly, about her treatment on the train. In Memphis, she hired an African-American attorney to sue the railroad. And when her lawyer was paid off by the railroad, she hired a white attorney. She won her case on December 24th, 1884, when the local circuit court granted her a $500 award. The railroad company appealed to the Tennessee Supreme Court, which reversed the lower court's ruling in 1887, and Wells was ordered to pay court costs. Her reaction to the higher court's decision revealed her strong convictions on civil rights and religious faith, as she responded, quote, "I felt so disappointed because I had hoped such great things from my suit for my people. Oh God, is there no justice in this land for us?" Wells would go on to create the National Association of Colored Women in 1896, and she was a founding member of the NAACP, and she ran for a seat in the Illinois State Senate and worked with the National Equal Rights League. Let's look at Plessy versus Ferguson, 1896. This case stemmed from a June 7, 1892 incident in which a train passenger by the name of Homer Plessy, depicted below, refused to sit in a car for black people after purchasing a first-class ticket. Now, this was a deliberate test case that was planned to see how the railroad would react to Homer Plessy. And he was a man of mixed race. He was called an octoroon, i.e. he was 7/8 white and 1/8 black ancestry. And he was born a free man, and he was a fair-skinned man of color. So, however, under Louisiana law, he was classified as black and thus required to sit in the colored car. Rejecting Plessy's argument that his constitutional rights were violated, the Supreme Court ruled that a law that implies merely a legal distinction between white people and black people was not unconstitutional, a setback. In 1896, the Supreme Court ruled in Plessy versus Ferguson that racially segregated public facilities were legal so long as the facilities for black people and whites were equal, Jim Crow laws. The ruling constitutionally sanctioned laws barring African Americans from sharing the same buses, sharing the same schools, and sharing the same public facilities as whites, again, known as Jim Crow laws, and it established the separate but equal doctrine that would stand for the next 6 decades. Now let's talk about Paulie Murray, born 1910, passed 1985, and her partner, Adeline McBean. I have no birth or death records on her, unfortunately. But Paulie was a civil rights activist. She became a lawyer, a women's rights activist, an Episcopal priest, and author. And 15 years before Rosa Parks in Montgomery, these 2 young black women were arrested on a bus near Petersburg, Virginia. And like Rosa, both women were already actively engaged in the struggle for racial equality. And by the time they boarded an old bus bound for Durham, North Carolina in late March 1940, Paulie Murray and her partner Adeline McBean had long discussed how they could most effectively challenge racial segregation. Now, the poor condition of their bus gave them the opportunity to translate their thoughts into action. Seated near the back of the bus, directly over a wheel, and that's awful if you ever sit in the back of a bus over a wheel, the 2 young women suffered with each and every bump. And when Adeline began to feel a sharp pain in her side, she and Paulie occupied seats in the middle of the bus, and the driver told them to move back, and they refused. After a lengthy debate with the driver and local police officers, the 2 women were arrested, and Paulie wrote her friends soon after her arrest, quote, "We did not plan our arrest intentionally. The situation developed, and having developed, we applied what we knew of satyagraha on the spot." Now, Gandhi used the word satyagraha, combining the Sanskrit for truth and holding firm to refer to his particular approach to nonviolent civil disobedience. In 1950, Paulie would publish States' Laws on Race and Color, an examination and critique of state segregation laws throughout the United States. Paulie Murray. Now, Irene Morgan Kirkcaldy, 1917 through 2007. Now, Irene Morgan had been dealing with a recent miscarriage, and she was visiting her mother in Gloucester County, Virginia, to physically and mentally recover from the ordeal. She was hoping to go back home so she could continue working on the production line for the B-26 Marauder, and she boarded a Greyhound to return to Baltimore. This is during World War II. And on July 16, 1944, Irene Morgan boarded the Greyhound bus, and she sat down next to another African-American woman who was carrying an infant. An African-American could not sit next to or across from a Caucasian passenger, but there were no designated black or white seats on the bus. When a white couple boarded the bus at a stop in Middlesex County, Virginia, the bus driver ordered Irene and her seatmate to surrender their seats. Her seatmate immediately retreated to the back of the bus with her infant, but Morgan refused to give up her spot. When Morgan would not move, the bus driver hopped off the bus to grab a sheriff. The sheriff presented Morgan with an arrest warrant, but she tore up the piece of paper and threw it out of the window of the bus. When the sheriff touched her to pull her out of her seat, she kicked him in the groin. The sheriff got off the bus, and a different sheriff was sent on. Quote, she said, "He touched me. That's when I kicked him in a very bad place. He hobbled off, and another one came on. I was going to bite him, but he looked dirty, so I clawed him instead. I ripped his shirt. We were both pulling at each other. He said he would use his nightstick. I said, we'll whip each other. Morgan was arrested and charged with resisting arrest and violating Virginia's Jim Crow transit law. On October 18, 1944, Morgan attended a court case, and she agreed to pay a $100 fine for resisting arrest, but refused to plead to the segregation violation. Since Maryland did not enforce segregation for interstate travel, Virginia's Jim Crow law could possibly not apply to Morgan. Morgan's case, with the help of the NAACP, was taken to the Virginia Supreme Court, and the Supreme Court ruled her in violation of the law. Morgan then took her case to the U.S. Supreme Court and won. Her case, Irene Morgan versus Commonwealth of Virginia, 328 U.S. 373, year 1946, was argued by William H. Hastie, the former governor of the U.S. Virgin Islands and later a judge on the U.S. Court of Appeals for the Third Circuit. And Thurgood Marshall of the NAACP was co-counsel. The U.S. Supreme Court ruled 6-1 in 1946 that Virginia's state law enforcing segregation on interstate buses was unconstitutional. Hastie and Marshall used an innovative strategy to brief and argue the case. Instead of relying upon the Equal Protection Clause of the 14th Amendment, they argued successfully that segregation on interstate travel violated the Interstate Commerce Clause of the U.S. Constitution. Irene Morgan said, if something happens to you which is wrong, the best thing to do is have it corrected in the best way you can. The best thing for me to do was to go to the Supreme Court. Lily Mae Bradford, born 1928, passed 2017. She was an American civil rights activist who 4 years before Rosa Parks' more publicized action performed an act of civil disobedience on a city bus in Montgomery, Alabama, for which she was arrested on a charge of disorderly conduct. On May 11th, Bradford saw that the bus driver had punched her ticket for the wrong price. According to Lily Mae, she said, apparently a costly and frequently occurring error, if it was indeed an error. Bradford asked to be charged the correct price, and after being told twice to return to the back of the bus, she sat down in the front, in the white section. The 20-year-old was going home from her job caring for disabled white children. She had paid for a transfer onto another bus, but as often happened, the driver had punched it in the wrong place, and if she did nothing about it, she would have ended up paying for the mistake, paying twice. Quote, I thought, if I don't get up and start speaking for my rights, I never will. It was humiliating. It was not dignified. It was off limits to go up to the front of the bus, but I went up there and I told him that my ticket hadn't been punched right. He said, he uses the N-word, go to the back of the bus. And I said, I will as soon as you give me the right transfer or give me my money back. And then I took a seat in the white folks section. The driver never fixed the punch card and Bradford never left the front seat. She was arrested for disorderly conduct, booked, fingerprinted, and paid a small fine. She was held by police for disorderly conduct until a neighbor bailed her out. And the arrest followed her throughout her life. She said it had prevented her several times from getting jobs she applied for. In 2006, she commented, there was always a box that said, do you have a criminal record? I went for federal clerk positions and I would pass the tests, but I wouldn't get the job. That's when I came to the conclusion that it was because I had a police record. Now let's look at Sarah Louise Keyes Evans, known as Sarah Keyes. Born in 1929. On August 1st, 1952, Women's Army Corps Private First Class Sarah Louise Keyes, age 23, traveled from Fort Dix, New Jersey to her family's home in Washington, North Carolina. During a stop to change drivers, she was told to relinquish her seat to a white Marine and move to the back of the bus. Keyes refused to move, whereupon the driver emptied the bus, directed the other passengers to another vehicle, and barred Keyes from boarding it. When Keyes asked why she shouldn't ride the bus, she was arrested and spent 13 hours in a cell, scared, pacing, and crying. Keyes was eventually ordered to pay a $25 fine for disorderly conduct and was released and put on a bus to her hometown. Her case was brought before the Interstate Commerce Commission and wasn't settled until November 7, 1955. In Sarah Keyes versus Carolina Coach Company, the ICC favored Keyes, ruling the Interstate Commerce Act forbids segregation. She said, quote, I knew I had been unjustly accused of disorderly conduct. I was willing to prove that I wasn't disorderly. There was nothing disorderly going on that night. My father said when you purchased a ticket, make sure the bus goes straight through with no stops. In other words, nobody could question her. In other words, you wouldn't be hassled by the driver. I didn't set out to do what I did. It just happened. I wasn't going to get up and walk through a crowd to stand. I was tired. It was around midnight, and you're just anxious to get where you were supposed to be. In retrospect, Sarah was a law-abiding young woman who certainly was not looking for trouble. It found her, and rather than wilt in the face of confrontation, she did like many before her. She rose, stood, and fought with pride and grace. Most importantly, she said she fought with the resolve that America had the willingness to change itself. Sarah Case. Let's look at Mary Fair Burks, born 1914, passed 1991. She was an American educator. In fact, she was a chairperson of the English department at Alabama State College, a scholar and activist during the Civil Rights Movement from Montgomery, Alabama. Burks founded the Women's Political Council, you'll hear me say WPC, in the year 1946, which helped initiate the Montgomery bus boycott following the arrest of Rosa Parks in December of 1955. Back to the year 1935, Mary Fair Burks was involved in an incident with a white female motorist that led to her being arrested by a white police officer. The incident demonstrated the prevalence of racism in Montgomery to Burks, which she had felt previously shielded her due to her education level and status. It also inspired Burks to focus her attention towards advocating for racial equality in Montgomery, Alabama, so she founded the WPC, the Women's Political Council. And the WPC focused its efforts around promoting civic involvement, increasing voter registration numbers, and lobbying city officials to address racist policies. Now let's go to Joann Robinson, born 1912, passed 1992. She was an instrumental figure in initiating and sustaining the Montgomery bus boycott, and she was also an unspoken critic of the treatment of African Americans on public transportation. In his memoir, Stride Towards Freedom, Martin Luther King said of Joann, apparently indefatigable, she, perhaps more than any other person, was active on every level of the protest. She was born in Culloden, Georgia, and she was the youngest of 12 children. Joann graduated as valedictorian of her high school class and went on to earn her BS from Fort Valley State College, becoming the first person in her family to graduate from college. Robinson taught for 5 years in Macon's public school system, where she was married to Wilbur Robinson for a short time. She then moved to Atlanta, Georgia, to earn her MA in English from Atlanta University. And following a year of study at Columbia University, where she received yet another master's degree, she taught briefly at Mary Allen College in Crockett, Texas, before moving to Montgomery in 1949 to teach English at Alabama State College. In Montgomery, Joann was active in the Dexter Avenue Baptist Church and the Women's Political Council, WPC. In 1949, Robinson was verbally assaulted by a bus driver, cursing her to get off his bus for sitting in the fifth row of the whites-only section on a nearly empty public bus. The whites-only section was completely empty, and she left the bus in tears. Out of fear that the incident would escalate and that the driver would go from verbal abuse to physical, Robinson left the bus. And a response to the incident was to attempt to start a protest boycott against bus segregation in Alabama. However, when Robinson approached fellow WPC members with her story and proposal, she was told that it was a fact of life in Montgomery. In late 1950, she succeeded Mary Fair Burks as president of the WPC and helped focus the group's efforts on bus abuses. Robinson stated in her memoir that, quote, members felt that young concerned women with their futures ahead would benefit by the WPC and that we would help them to organize and select goals and directions for their future. To further her efforts, Robinson met with the mayor of Montgomery, Alabama at the time, William A. Gale. His name will come up in the case with Aurelia Browder. Robinson also met with the Montgomery City Commission, but they weren't interested in what she had to say. And when City Hall's leaders were no help, Joann took matters into her own hands and organized a boycott once again. And she said, quote, people the world over should know that any group if given equal opportunity in education, employment, civil rights, and the like can be desirable citizens anywhere with as much to offer as any other group. So after the Supreme Court decision in Brown versus Board of Education, Robinson informed the city's mayor that a bus boycott might ensue if bus service did not improve, but negotiations had yielded little success by late 1955. Let's look at Brown versus Board of Education, 1954. In the case that would become a lawsuit, a plaintiff named Oliver Brown filed a class action suit against the Board of Education of Topeka, Kansas in 1951, after his daughter Linda Brown was denied entrance to Topeka's all-white elementary schools. And that's Linda on the right there. In his lawsuit, Brown claimed that the schools for black children were not equal to the white schools and that segregation violated the so-called Equal Protection Clause of the 14th Amendment, which holds that no state can deny to any person within its jurisdiction the equal protection of the laws. The case went before the U.S. District Court in Kansas, which agreed that public school segregation had a, quote, detrimental effect upon the colored children and contributed to a sense of inferiority, but still upheld the separate but equal doctrine. When Brown's case and 4 other cases related to school segregation first came before the Supreme Court in 1952, the court combined them into a single case under the name Brown versus Board of Education of Topeka. Thurgood Marshall, the head of the NAACP Legal Defense and Educational Fund, served as chief attorney for the plaintiffs. He would later become the first black Supreme Court justice. So at first, the justices were divided on how to rule on school segregation, with Chief Justice Fred M. Vinson holding the opinion that the Plessy verdict should stand, separate but equal. But in September 1953, before Brown versus Board of Education was to be heard, Vinson died, and President Dwight D. Eisenhower replaced him with Earl Warren, who was then governor of California. Displaying considerable political skill and determination, the new Chief Justice succeeded in engineering a unanimous verdict against school segregation the following year. In the decision issued on May 17, 1954, Warren wrote that, quote, in the field of public education, the doctrine of separate but equal has no place, as segregated schools are inherently unequal. As a result, the court ruled that the plaintiffs were being deprived of the equal protection of the laws guaranteed by the 14th Amendment. In its verdict, the Supreme Court did not specify how exactly schools should be integrated, but asked for further arguments about it. In May 1955, the court issued a second opinion in the case, known as Brown versus Board of Education II, which remanded future desegregation cases to lower federal courts and directed district courts and school boards to proceed with desegregation with all deliberate speed. Though well-intentioned, the court's actions effectively opened the door to local judicial and political evasion of desegregation. While Kansas and some other states acted in accordance with the verdict, many school and local officials in the South defied it. In one major example, Governor Orville Faubus of Arkansas called out the state National Guard to prevent black students from attending high school in Little Rock, Arkansas in 1957. After a tense standoff, President Eisenhower deployed federal troops, and 9 students, pictured on the right, known as the Little Rock Nine, were able to enter Central High School under armed guard. Though the Supreme Court's decision in Brown versus Board didn't achieve school desegregation on its own, the ruling and the steadfast resistance to it across the South fueled the nascent civil rights movement in the United States. In 1955, a year after the Brown versus Board of Education decision, Rosa Parks refused to give up her seat on a Montgomery, Alabama bus. Now let's talk about Claudette Colvin, born in 1939. She was a pioneer of the 1950s civil rights movement and a retired nurse's aide. Her stand was part of a long history of African-American resistance, as acts of resistance on segregated transportation had been going on for more than a century. When Claudette Colvin's high school in Montgomery, Alabama, observed Negro History Week in 1955, the 15-year-old had no way of knowing how the stories of black freedom fighters would soon impact her life. Quote, I knew I had to do something. I just didn't know where or when. Colvin got her chance on March 2, 1955, when she boarded a bus in downtown Montgomery. She and 3 other black students were told to give up their seats for a white woman. Colvin, emboldened by her history lessons, refused. Quote, my head was just too full of black history. It felt like Sojourner Truth was on one side pushing me down, and Harriet Tubman was on the other side of me pushing me down. I couldn't get up. In 1955, Colvin was a student at the segregated Booker T. Washington High School in the city, and she relied on the city's buses to get to and from school because her parents didn't own a car. Now, the majority of customers in the bus system were African American, but they were discriminated against by its custom of segregated seating. On March 2, 1955, she was returning home from school, and she sat in the colored section about 2 seats away from an emergency exit in a Capitol Heights bus. If the bus became so crowded that all the white seats in the front of the bus were filled until white people were standing, any African Americans were supposed to get up from nearby seats to make room for whites, move further to the back, and stand into the aisle if there were no free seats in that section. When a white woman who got on the bus was left standing in the front, the bus driver, Robert W. Cleary, commanded Colvin and 3 other black women in a row to move to the back. The other 3 moved, but another pregnant woman, Ruth Hamilton, got on and sat next to Colvin. That's my presentation. It's my seat. I'm John Horrigan. Thank you so much for watching. This is part 1 of It's My Seat.